So Parliament is expected to soon approve regulations that would raise children's criminal liability from 10 to 12 years of age. So once this is given the green light, the regulations can be gazetted and the law can come into effect. Criminal capacity is the age at which a child is presumed to be mature enough to understand the difference between right and wrong and can therefore be prosecuted for committing those crimes. To help us understand this better, we're joined now by criminal lawyer Sumaya Wadee Mahomed. She joins us via our video link this morning. Sumaya, it's great to have you with us on the program this morning. Can you explain to us what has been the situation up to now? Because if the age is being increased from 10 years to 12 years, 10 years does seem incredibly young for a criminal liability of a child.
Yes, good morning, Michelle. Look, the question of exactly when a child reaches this benchmark of criminal capacity or where that child can be held legally accountable is complicated and is a matter which sort of extends as far back as 753 BC in Roman law. So historically there has been a progressive evolving of the law around children and their ability to be held accountable for their actions. In our law, South Africa specifically, our law is informed by Roman Dutch law, and more recently, after the fall of apartheid, there was a push towards the government to address the treatment of children or children being held criminally liable for crimes. That sort of kicked in a long process which stems back to the 1980s. You must remember that we are also signatories. South Africa is signatories to international instruments, the most formative being the UN Convention on the Rights of the Child, the Beijing Rules, which give us the UN standard minimal rules of the administration of criminal justice, etc. And for all intents and purposes, this move or the step to increase is in line with the United Nations General Comment number 10 in 2007, which found that fixing a minimum age of criminal capacity of not lower than 12 years was recommended for state parties. And state parties were advised to progressively raise the minimum age where possible. So it's been a long time coming. In fact, in terms of South African law, before the commencement of the Criminal Justice Act in its current form, we were minors charged with criminal offences were treated almost as a younger version of an adult offender. And various legislation in South Africa allowed for some differentiation in the treatment of minors. However, the condition of children was high on the agenda, and the process of reform started. So the common law presumption was that children under the age of 7 irrebuttably were presumed to lack criminal capacity.
Under the age of 7, you said?
That was the previous position. In terms of the common law, children under the age of 7 were presumed to lack a criminal capacity, and they were dollar unpacks. Thereafter, the Child Justice Act was enacted, and the Child Justice Act saw an implementation of the minimum age of 10. Now what we are looking at is the draft Child Justice Bill was introduced in Parliament in, it's a long process, and the Child Justice Act commenced into 2010, in April 2010, and now what we're looking at essentially is the amendments that were recommended under the Child Justice Act, which are also a long time coming and very late.
So Sumaya, I want to just unpack this with you. So the minimum age now moves from 10 to 12, but there is an assumption that children 12 to 14 don't have criminal capacity. Is that correct?
Right. So children under the age of 12, once this law is promulgated and come into effect, would be deemed to lack criminal capacity, irrebuttably, and they would not be able to be prosecuted in the ordinary course in the criminal justice system. However, children from the ages of 12 up to the age of 14 will be rebuttably presumed to lack criminal capacity, meaning that they would be able to be found to have criminal capacity if the state proves beyond reasonable doubt that that accused child has the criminal capacity to commit a crime.
Right. I understand that the amendment also removes the requirement that prosecutors must consider a child's cognitive ability when attempting to prosecute a child. So how does that process happen? Because a prosecutor obviously is not equipped to do that.
Right. So in terms of Section 10, the decision to prosecute a child who is 12 years or older but under the age of 14, all that happened was they changed they changed the reference to cognitive ability and they included additional references in Section 10F to add provisions for diversion, etc. So the change in that respect is more of a practical nature. You must understand that our criminal justice system and our justice system at large is beset with a number of problems. Some of it being the capacity or the capability of a national standardized assessments in terms of the tools that are used to assess criminal capacity. We have a lack of resources. We have overburdened courts. We have I can go on and on. So the Act doesn't address the problems in the current criminal justice system, but it does sort of make South Africa compliant with international standards and the move by international you must remember that developmentally and in terms of psychological theory, social theory, etc., children are presumed to not be able to control their responses and before the age of 14. So the movement or the upping the age is in line with the theories around developmental of children, etc.
Yeah. I want to ask you, Sumaya, because basically you're saying it's not a blanket decision that's being made here. There are still processes that need to unfold in any criminal case involving a child where an assessment of a particular child needs to be done if that child is under the age of 14. Do any cases for you in the South African context spring to mind that involve the criminal capacity of a child at this age?
You know, our criminal justice system is traditionally very slow. There has been, you must understand that in terms of South African law and the practical application of the criminal justice system, children commit crimes lacking in capacity or in that sort of gray area of having to be assessed, etc. However, at the time of sentencing, sometimes at the time when officials choose to lay charges, when children are actually caught or taken into detention for those crimes, they may be much older. So there are practically a lot of sort of challenges. I don't have any, nothing springs to mind at the moment. I'm suddenly blank.
No, I have put you on the spot.
Yes, you have.
But it's an incredibly important discussion, certainly, and I think one that we will continue to flesh out, particularly as the conversations around these new regulations continue. So children, in terms of criminal liability, the age now has been increased from 10 years to 12 years of age. Sumaya Wadee, thanks so much for your time this morning on the AM Report. An attorney and director at AW Incorporated.